Hello mga House of Law, I'm back. Sa mga 2023 bar examinees, congratulations sa pagtatapos ng bar exams. Hurdling the 3 examination days is an achievement in itself. You deserve a big round of applause. Bravo, bravo. Now, we wait. You have done your very best, now let God do the rest. And speaking of rest, you deserve to have a long and relaxing break. So nasaan ba kayo ngayon? Nasa beach? Nasa bundok? O nasa kwarto at nagbi-binge watch ng Netflix? Kalimutan na muna ang bar exam. Although, do not stop praying dahil as declared by Justice Hernando, lalabas ang results by the end of the year. And if the Supreme Court's calendar will permit it, baka before the new year of 2024 ay mga abogado na kayo. God willing. Now, I know you are strong and bold enough to watch this video. I will answer the 2023 Civil Law Bar Exam. Siyempre, proud ako dahil nahulaan ng mahiwagang fishbowl ang 5 out of the 20 questions. It may not be 100% like the predictions of someone I know na nagtuturo ng remedial law, sana all, pero 5 is a good number. It's good enough, lalo na considering na yung situation sa questions number 3 at number 12 ay eksaktong-eksakto dun sa hula. That is a wonderful coincidence, di ba? Speaking of which, thank you for watching my predictions video. Naging viral siya, kahit mga lawyers na nga ay pinanood pa rin siya. So, see you again daw next year, sabi ng mahiwagang fishbowl. So without further ado, here are my suggested answers to the 2023 Civil Law Bar Exam. Christopher, a citizen of the United States, married Laila, a Filipino, in Dallas, Texas. Their marriage was later terminated by a divorce decree issued by a U.S. court. At that time, their child, Amado, was only 18 months old. Laila and Christopher returned to the Philippines and settled in El Nido, Palawan. Christopher allegedly promised to give support to Amado in the amount of $1,000 per month. But he never did. Subsequently, Christopher also settled in Cebu where he cohabited with another Filipino woman. When Laila learned of the whereabouts of Christopher, she filed a complaint against him for violation of the Anti-Violence Against Women and Their Children Act for his failure or refusal to support Amado. Laila also invoked Article 195 of the Family Code, which provides for those who are obliged to support each other. She argued that notwithstanding their divorce, Christopher is not excused from complying with his obligation to support Amado. Is Laila correct in invoking Article 195 of the Family Code? Explain. Bakit ganon? Pagka first question, nakakakaba talaga. It doesn't make it any easier when the question has so many facts and issues. Tulad nito, sa unang tingin, akala mo foreign divorce ang issue. Sa pangalawang tingin, parang vowsy naman. Yun pala, support ng bata. Also, I noticed na with all due respect to the Supreme Court and the examiner, the bar chair, Justice Hernando, may medyo parang typographical error dito, I think, ha? Kasi dapat ata ang sinabi ay Laila and Amado returned to the Philippines and settled in El Nido, Palawan. Bakit si Amado dapat at hindi si Christopher? Kasi sa subsequent sentence, sinabi na Christopher also settled in Cebu. Diba? Tama ba mga mi? Anyway, very minor lang naman ito. Sana hindi kayo nalito or kung nalito man sa una, naliwanagan din agad kayo. Anyway, so here the call of the question is Laila correct in invoking Article 195 of the Family Code? To answer this question, you have to recall kung may kaso na na-decided na ang Supreme Court dito. If not, then just recall kung ano yung Article 195. Thankfully, may clue sa previous 2 sentences. The provision talks of persons who are obliged to support each other. So you will remember na kasama doon ang parents and children. But in relation to that, you will also have to remember the effect of the divorce kung meron man. Include that in the development of your answer. So, sagutin natin. Actually, ang question na ito ay katulad sa kaso ng Supreme Court na Del Socorro versus Wilson GR number 193707, December 10, 2014. I don't think the Acharon versus People case will be used here because the question is not about criminal liability. The question is the civil obligation to give support. Anyway, here is my suggested answer. Yes, Laila is correct. Under Philippine law on support, parents are obliged to support their children. This applies most especially if the child is still a minor. The separation of the parents or the termination of their marriage does not affect this unless otherwise ordered. In case of mixed marriage between the parents where one of the parents is a foreigner, his or her national law shall govern his family rights and duties, including the obligation to give support, unless that foreign national law cannot be observed because it is against Philippine public policy. In this case, Christopher is the father of Amado who has a right to receive support from him. Christopher's divorce from Amado's mother did not change that obligation, at least under Philippine law. Even after being divorced from Amado's parents and even assuming the divorce terminated the obligation to give support under the law of the country granting the divorce, the duty is still enforceable in the Philippines because it would be of great injustice to the child to be denied of financial support when the latter is entitled thereto. Hence, Christopher is still obliged to give support to Amado. Nida and Deogracias were college sweethearts who had a child together named Michael. When Michael was 3 years old, Nida and Deogracias both died in a car accident while still planning their future wedding. Michael was then put in the care of the unmarried sister of Nida, Nina, who officially adopted Michael. A few years later, Nina left to work in the United States. Michael was left to live with his grandmother Aurora in the Philippines. In the US, Nina bore an illegitimate child, Maricel, from her affair with a married man. When Maricel was 22 years old, Aurora died, so Nina came home to the Philippines with Maricel for the funeral. Maricel finally met Michael, who is now 28 years old. The two of them fell in love and planned to get married. Nina objected, saying that their marriage was prohibited by law. Can Maricel and Michael validly get married? Explain your answer. Naku, tumalon na naman ang puso ko nung binasa ko ang question na ito. Akala ko adoption, tapos mana. Yun pala kasal ng mag-step siblings. Anyway, mag-half-brother sister sila na in love at gusto magpakasal. Recall your void marriages kung kasama ba ang adopted child and illegitimate child of the adopter. So here is my suggested answer. Yes, Maricel and Michael can validly get married. The family code enumerates the void marriages for reasons of public policy. They are marriages between specific blood relatives, including those between an adopted child and a legitimate children of the adopter. In this case, Michael is the adopted child of Nina, while Maricel is the illegitimate child of Nina. They are not among those prohibited to marry. Hence, they can validly marry. In 1981, JR married then 16-year-old Inca in a civil ceremony solemnized by the mayor in their hometown. The couple lived together until 2007 when JR confessed to having an affair with Elena. Inca later discovered that JR and Elena got married in 1995. Inca thus filed a criminal complaint against JR for bigamy. In his defense, JR insisted that he could not be held criminally liable for bigamy because his marriage with Inca in 1981 is void for lack of a valid marriage license, while his marriage with Elena is void for lack of a marriage ceremony. Meanwhile, Elena claimed that even prior to the bigamy case, she already filed a petition for nullity of marriage before the Regional Trial Court of Quezon City sometime in 2007 after learning about the marriage between JR and Inca. The RTC later declared the marriage of JR and Elena as void for being bigamous and the ruling attained finality due to lack of appeal. Does JR have a valid defense in the bigamy case? Decide with reasons. Dito sa question na ito, una ko napansin yung edad ni Inca. Then binasa ko ulit, ayun, 1981 sila kinasal, so pwede. It was in 1988, mga House of Law, after the family code was adopted that the marrying age was adjusted to 18 years old. Then further reading it, I felt a strange feeling, a feeling na nanalo sa loto. Bakit? Dahil nahulaan ito ng mahiwagang fishbowl. Ito ang pulido versus people. So here is my suggested answer. Yes, JR has a valid defense. In the recent Supreme Court decision in Pulido versus People, it was ruled that a void ab initio marriage is a valid defense in the prosecution for bigamy even without a judicial declaration of absolute nullity. A marriage license and the marriage ceremony are formal requisites of marriage. The absence of any of them renders the marriage void ab initio. In this case, JR's marriage to Inca lacked a marriage license, while JR's marriage to Elena lacked a marriage ceremony. Both are void marriages. As a matter of fact, a court had already declared the marriage between JR and Elena as null and void. Thus, these can be raised and proved by JR in the criminal case for bigamy. Santiago and Lucia started to live together as common law husband and wife in 2000. In the course of their relationship, they acquired several properties which included a 600 square meter house and lot in Quezon City, a condominium unit in Taguig City, a 4-hectare rest house in Batangas, a Range Rover vehicle, Lexus RX 350 car, and an Indian Chief Bobber motorcycle. The purchases were made mainly due to the successful salon and water refilling business of Lucia. Unfortunately, the records of these purchases were destroyed during Typhoon Ondoy in 2009. In 2023, their relationship turned sour and Lucia now wants to part ways with Santiago. However, there is a disagreement on how to divide their properties. Lucia filed a case in the family court claiming that she is entitled to all of the properties. Is Lucia correct? Explain briefly. Sa first sentence pa lang naisip ko na agad na property relation ito ng mag-live-in. Yun nga. Pero medyo na-amaze lang ako sa yaman ni girl. Alta si Lucy at mahilig sa mamahaling kotse. Okay, yun nga lang, wala siyang resibo na makapagpapatunay na siya ang bumili ng mga ito. So in answering this question, recall the family code provisions on property relations of unions without the benefit of marriage. So here is my suggested answer. No, Lucia is not correct. Under the family code, when a man and a woman who are capacitated to marry each other live exclusively with each other as husband and wife without the benefit of marriage, their properties are presumed to have been obtained by their joint efforts unless there is proof to the contrary. The party who did not participate in the acquisition shall be deemed to have contributed through efforts to care for and maintain the family and the household. In this case, Lucia claims that the real and personal properties were purchased mainly due to her successful salon and water refilling business. However, records of these purchases were allegedly destroyed during Typhoon Ondoy in 2009. There is also no agreement regarding these properties. Thus, the properties shall be presumed to be jointly owned by Santiago and Lucia and shall be divided equally between them. Melchor, a Filipino, met and married Amy, a Parisian model in France. They had 2 daughters named Anna and Karenina. Eventually, they decided to settle in the Philippines. However, unknown to his family, Melchor was having an affair with another Parisian model, Genevieve. He arranged for Genevieve to reside in the Philippines and bought her a house in North Green Hills so that they could continue with their illicit affair. Juliet was born out of their affair. Juliet grew up not knowing that she was the illegitimate daughter of Melchor until the death of the latter. Upon discovering that her father had a legitimate family, Juliet sought to be recognized as an illegitimate daughter of Melchor since she had always longed for sisters. In her action to prove her illegitimate filiation, Juliet presented her birth certificate, signed by Melchor, as well as photographs of her with Melchor in their home in North Green Hills. Amy, Anna, and Karenina opposed the action of Juliet. Will the action of Juliet prosper? Explain your answer. When I was reading this question and saw the illegitimate child situation, initially naisip ko, ay, Amadea Aquino. But then I was wrong kasi establishing filiation lang pala ang issue. So sa question na ito, you will have to decide whether the evidence of Juliet are sufficient to establish her status as an illegitimate child of Melchor. Recall the evidence needed to establish the filiation of an illegitimate child and when the action should be filed. So my suggested answer is, yes, Juliet's action will prosper. Under the family code, the filiation of an illegitimate child shall be established in the same way and on the same evidence as a legitimate child. The action must be filed during the lifetime of the child if based on primary evidence, or during the lifetime of the parent if based on secondary evidence. A certificate of birth is primary evidence, while photographs of the child with a putative parent are secondary evidence. In this case, Melchor has already died, but Juliet is still alive. Her action based on her certificate of birth, which is primary evidence, is timely filed because it was filed during her lifetime. Thus, Juliet may proceed to prove her status as Melchor's illegitimate child. With the express consent of their respective parents, Jamie and Kathy, both 21 years old, decided to get married in a destination wedding in Boracay on Valentine's Day 2022. The older brother and sister-in-law of Jamie were on their way home from the wedding on board a boat when it sank, leaving their 8-year-old son, Cesar, orphaned. Grief-stricken, Jamie and Kathy now want to adopt Cesar and raise him as their own. Are they qualified under the law to adopt Cesar? Explain your answer. After reading the question, naisip ko, pwede naman. Kawawa naman kasi si Cesar. Sakto, kakakasal lang ni Jamie at Kathy, may instant anak na sila kung sakaling i-adopt nila ang pamangkin nila si Cesar. Diba? Pero nothing is what it seems. Charot. So I remember, nahulaan ito ng mahiwagang fishbowl. Republic Act 11642 at ang mga pagbabago sa mga kwalifikasyon ng adopter. Napansin nyo ba ang edad ni na Jamie at Kathy? So here is my suggested answer. No, they are not qualified to adopt Cesar. Under the new adoption law, an adopter must be at least 25 years old and at least 16 years old older than the child to be adopted. In this case, both Jamie and Kathy were just 21 years old and barely 13 years older than Cesar. Thus, they do not meet the age qualification to adopt Cesar. Basic. Anita is an entertainer in Imperia, a men's club and lounge. One evening, Billy, the exclusive patron of Anita, asked her out on a date outside of Imperia. After spending the night together, Billy got Anita pregnant. A year after giving birth to Marisol, and despite the vehement opposition of Billy, Anita went back to her previous job in Imperia to support her child. Anita was able to provide a house, a nanny, and other necessities for Marisol. Billy, however, insisted that Anita no longer needed to work if she and Marisol stayed with him as he could provide for them. Since Anita refused to live with Billy, the latter filed a petition for custody of Marisol. Anita contended that illegitimate children are automatically under the sole custody and parental authority of the mother. On the other hand, Billy alleged that Anita is unfit to take care of Marisol given her line of work. If you are the judge, how will you decide the petition? Explain. You know, I love questions that challenge stereotypes. So here we have the male stereotype who is supposed to protect and shelter women and children and thinks that women can't and should not work. But our biases aside, ang issue dito ay whether Anita is not fit to exercise parental authority and custody over her child Marisol. So here is my suggested answer. If I were the judge, I will deny Billy's petition. Under the family code, an illegitimate child shall be under the exclusive parental authority of the mother. Further, no child below 7 years old shall be separated from the mother unless the court finds compelling reasons to order otherwise, such as immoral acts that have an adverse effect on the welfare of the child. In this case, Marisol is Anita's illegitimate child and is still less than 7 years old. Anita's work as an entertainer in a men's club and lounge is not immoral per se. There is also no evidence to show that Anita's work has a direct adverse effect on the welfare of her child. Thus, Marisol should remain under the parental authority and custody of Anita. Nicolo and his girlfriend Mayan were classmates in medical school. When they finished their studies and started earning, they decided to invest in a condominium unit together which they hoped to lease out. Since Nicolo came from a rich family and was still receiving an allowance from his parents, the couple decided that Nicolo would shell out 2/3 or 10 million pesos of the 15 million purchase price, while Mayan would contribute 1/3 or 5 million pesos. They asked a mutual friend who was a law student to draw up a contract which reflected the mentioned interests. The contract also had a provision that their shares in the benefits as well as the charges affecting the property would be equal. They then found a long-term tenant who rented the property for 30,000 pesos a month. Unfortunately, Nicolo and Mian broke up and are now quarreling over their respective shares in the rental income. Nicolo insists that he should get 20,000 pesos or two-thirds of the monthly income, while Mian claims that it should be 15,000 pesos each. Who is correct? Explain your answer. When I saw fractions in this question, sabi ko, ay patay na. Kaya nga nag-abogado kasi mahina sa math. Pero after reading the question, I realized, kaya naman pala. Kahit nga hindi i-compute, masasagot to. Anyway, the question talks about co-ownership and the rule on shares in the benefits as well as in the charges. So here is my suggested answer. Nicolo is correct. Under the Civil Code, the shares of the co-owners in the benefits as well as in the charges shall be proportional to their respective interests. Any stipulation to the contrary shall be void. So in this case, Nicolo's interest is 2/3 while Mayan's is 1/3. The provision in their contract that their shares in the benefits as well as the charges would be equal is a void stipulation. Thus, as correctly insisted by Nicolo, he should get 20,000 or 2/3 while Mayan should get 10,000 or 1/3 of the 30,000 monthly rental. Lani and Rufino died leaving 4 children, 2 of whom are Arturo and Bugoy. The heirs signed a document selling half of the property of their parents to their friend Honorato. One of the remaining quarters was occupied by Ildefonso and Bienvenido, the children of Arturo, while the other half was sold by Bugoy to the spouses Cruz by virtue of a deed of sale. Shortly after, the spouses Cruz filed an ejectment case against Ildefonso and Bienvenido for the 1/4 portion of the subject property that they purchased. On the other hand, Bienvenido filed a complaint for recovery of ownership, quieting of title, and annulment of deed of sale against the spouses Cruz. He alleged that the deed of sale is void since Bugoy is not the true and real owner of the subject property, which originally belonged to the estate of Rufino. On the other hand, the spouses Cruz argued that Bienvenido availed of the wrong remedy and claimed that the heirs had already agreed to divide the property among themselves when they allowed a portion of the property to be occupied by the heirs of Arturo. Will the complaint of Bienvenido prosper? Discuss. To be honest, nalito ako ng slight dito sa tanong na ito. 3 beses ko ata binasa ang tanong and then I realized nahulaan ito ng mahiwagang fishbowl. Co-ownership and sale of a specific portion of the co-owned property. So it is clear that there was a co-ownership pero the co-owners decided to sell 1/2 of it. Now, for the other half, I had to make sure kung may partition na ba between Arturo and Bugoy. Well, walang express or formal partition pero may pag-exercise na ng exclusive rights over a certain portion of the property. So, here is my suggested answer. Okay, no, Bienvenido's complaint will not prosper. Settled is the rule that a co-owner can only sell an undivided interest or share in the co-ownership prior to partition. The sale of a specific portion is void unless it is consented, ratified, or when the other co-owners are stopped from questioning it. In this case, Arturo and Bugoy were co-owners of their inherited property. After previously selling the other half, they remain co-owners of the remaining half. When Arturo's children, one of whom is Bienvenido, occupied 1/4 of the property, Arturo and his children have effectively selected their definite portion, resulting in the partition of the property. Thus, Bienvenido cannot question the sale by Bugoy of his respective portion to the spouses Cruz. Marvic inherited a piece of land and decided to farm it. The land was bordered on all sides by properties belonging to other owners. The surrounding property closest to the public highway is owned by Renato. Willing to pay compensation, Marvic talked to Renato about granting him access to the highway, but Renato refused. Renato reasoned that there is another access point for Marvic through a dirt road that connects to the public highway without passing through his property. Marvic argued that this is not convenient as it is twice the distance, circuitous, and unlit. As they could not reach an agreement, Marvic filed a complaint for easement of right-of-way against Renato. Should a compulsory right-of-way be granted in favor of Marvic? Explain your answer. Okay, for this question, I had to take note of the actual access situation of Marvick's property. Surrounded nga siya ng ibang properties on all sides. Pero note, hindi siya totally locked in or deprived of any access to the public highway. Maarte lang talaga siya. Ayaw niya maglakad ng malayo. Ayun. So, here is my suggested answer to question number 10. No, Marvick is not entitled to a compulsory right-of-way. According to the Civil Code, the requisites of a compulsory easement of right-of-way are: A. An immovable is surrounded by other immovables belonging to other persons and is without adequate outlet to a public highway. B. Payment of proper indemnity by the owner of the surrounded immovable. C. The isolation is not due to its owner's acts. And D. The proposed easement of right-of-way is established at the point least prejudicial to the servant estate and insofar as consistent with this rule, where the distance of the dominant estate to a public highway may be the shortest. In this case, the first requisite is absent. Marvick's property is not totally without any access to the highway. On the contrary, there is a dirt road that connects his property to the public highway. It is just that, according to Marvick, it is inconvenient. However, convenience is not a requisite for the easement of right-of-way. Hence, Marvick's complaint for easement of right-of-way should be dismissed. Alejandro was a married airline executive who had a clandestine love affair with a pilot, Francisca. 6 years later, Francisca ended the affair amicably because she wanted to get married herself and start a family. She soon met David, another pilot, and they got engaged. On the occasion of the impending nuptials of Francisca and David, Alejandro, feeling nostalgic and generous, donated a valuable painting, exclusively his own and not conjugal, to Francisca. Upon learning of the donation, the wife of Alejandro, who knew of the romantic past between the two, filed a complaint to have the donation nullified. Is the donation valid, void, or voidable? Explain your answer. After reading the initial facts, ang reaction ko, Noli Iyala, ikaw ba yan? Pero civil law nga pala ito, hindi legal ethics. Anyway, note that in this case, Alejandro was married when he had a clandestine love affair with Francisca. However, that affair had ended long before the donation. So here is my suggested answer. The donation is valid. Under Article 739 of the Civil Code, a donation between persons who were guilty of adultery or concubinage at the time of the donation shall be void. They must be engaged in the adulterous relationship at the time of the donation. Okay, in this case, the alleged adulterous relationship between Alexander and Francisca had already ended when Francisca decided to get married and Alexander decided to donate as a wedding gift to her a valuable painting which was Alexander's exclusive property. Hence, Alexander can validly donate the painting to his ex-beau, Francisca. Cora, who was married to Wenceslao, executed a last will and testament where she gave all of her exclusive properties to her niece Alma. Cora later died without issue. Wenceslao subsequently opposed the probate of her will on the ground that he was deprived of his legitim. Is Wenceslao correct? Explain your answer. Naku, tumalo ng puso ko after reading this. Patok si Mahiwaga Fishbowl. Preterition ang tanong. So here is my suggested answer. No, Wenceslao is not correct. As defined, preterition, which annuls the institution of heirs, is the omission in the decedent's last will and testament of a compulsory heir in the direct descending line. A spouse is not a compulsory heir in the direct descending line. Compulsory heirs that may be preterited are legitimate and illegitimate children, whether born or unborn at the time of the execution of the will. In this case, Wenceslao is only the spouse of Cora. Being a spouse, Wenceslao is not a compulsory heir in the direct descending line. His omission in Cora's will is not a case of preterition. Hence, Cora can validly give all of her exclusive properties to her niece Alma. Felicia and Rocky met at a training convention and subsequently became lovers. They had children, Enrico and Eurice. One night while on his way home, Rocky met his end when his car collided with a speeding 15-wheeler truck along C5 Road. A year later, the father of Rocky, Hilario, suffered a brain aneurysm and died. In the settlement of the estate of Hilario, Enrico and Eurice claimed an interest in the estate of their grandfather. They argued that as the biological children of Rocky, they are entitled to inherit from their grandparents by right of representation. The legitimate heirs of Hilario vehemently opposed the claim on the ground that Enrico and Euris are barred from inheriting from the ascendants of Rocky. Are the legitimate heirs of Hilario correct? Explain your answer. Naku, napatalon na naman ako nung nabasa ko ang tanong. Ito na talaga siya, Amadea Aquino. I had a strong feeling about it kasi nga landmark case siya. Kaya, ayun, salamat ulit, mahiwagang fishbowl. So, to this question, here is my suggested answer. No, they are not correct. Under the Civil Code, grandchildren, regardless of status, shall inherit from their grandparents by way of right of representation. The right of representation is the right of the children to take the place of their parents who predeceased the decedent. In this case, Enrico and Euris are illegitimate children of Rocky. Their illegitimate status is immaterial. Rocky died before his father Hilario died. What Rocky could have inherited from Hilario may go to Enrico and Euris by way of representation. Hence, Enrico and Euris may inherit from Hilario's estate. The promissory note between Joseph and Mario states, Joseph agrees and understands that upon failure on his part to pay the amount of 100,000 pesos on December 31, 2015, he agrees to pay the sum equivalent to 6% interest monthly from the date of default until the entire obligation is fully paid for. Joseph failed to pay on the stipulated date. On March 1, 2016, Mario filed a collection suit against Joseph. In his defense, Joseph stated that he was not yet in legal delay as Mario had not made a demand against him. Is the contention of Joseph correct? Explain. So upon reading this question, I remember Article 1169 of the Civil Code. Para dun sa mga students ko sa Civil Law Review at sa mga Bar Review Centers, alam nyo yan kung gaano ko lagi isinistress ang Article 1169. First, second, and third paragraphs nito, and the effect of delay, which is that it renders the obligor or debtor liable for damages or interest. Also remember that there is a difference between when the obligation is due and when the debtor is in delay. The obligation is due on the date fixed, whether or not there is demand. On the other hand, for the debtor to be liable for damages or interest under Article 1170 and 2209 of the Civil Code, dapat may prior demand, unless the exceptions under Article 1169, second paragraph apply. So here is my suggested answer. No, Joseph's contention is not correct. Under the Civil Code, for the effects of delay to arise, a demand must be made on the debtor, whether judicial or extrajudicial, unless the stipulation of the parties expressly dispenses with the need for demand. In this case, the stipulation that upon failure to pay the amount of 100,000 pesos on December 31, 2015, the debtor agrees to pay the sum equivalent to 6% interest monthly from date of default until full payment simply means that demand is not necessary for Joseph to be liable for interest. As to the maturity of the loan, it matured and became due and demandable on the date fixed, that is, December 31, 2015. Hence, the collection suit against Joseph will prosper. On September 6, 2015, Mauro purchased from Antonio a motorcycle as evidenced by a deed of sale. The purchase price was 88,700 with a down payment of 35,000 and the balance payable in 12 monthly installments, due and payable on the first day of each month starting December 1, 2015. As security for the balance, Mauro executed a chattel mortgage over the said motorcycle in favor of Antonio. However, Mauro failed to pay the monthly installments. After Antonio extrajudicially demanded payment for the balance, Mauro returned the property to Antonio. Is the return of the motorcycle equivalent to Dacion and Pago? Discuss. Nako, one of those nothing is what it seems kind of questions. After reading the initial facts, akala ko recto law, yung Article 1484 of the Civil Code. Yung pala Dacion and Pago. So nakuha nyo ba ito? Tricky, di ba? Isipin nyo na lang, tama ba na ang i-offer mo as Dacion and Pago ay yung bagay mismo na binili mo na at hindi mo pa nababayaran? So here is my suggested answer. No, the return of the motorcycle is not equivalent to Dacion and Pago. In Dacion and pago, as a special mode of payment, the debtor offers another thing to the creditor who accepts it as equivalent of payment of an outstanding debt. Here, the motorcycle is not another thing. The motorcycle is the very thing purchased which gave rise to an obligation to pay a sum of money. Nardo leased a house and lot from Jericho. Subsequently, Nardo subleased this property to Paquito. The contract of sublease contained a stipulation to the effect that the rental payments of Paquito should be paid directly to Jericho, the principal lessor. Is this a stipulation for autrui? Explain. It's been a while. Hey, stipulation for autrui. I suspected that this might be asked kasi nasa outline yung exception sa relativity of contracts. So anyway, here is my suggested answer. Yes, this is a stipulation for autrui. A stipulation for autrui is a stipulation in a contract between two parties in favor of a third person, which the latter may demand its fulfillment. It should be incidental to and not the main contract. In this case, Nardo and Paquito entered into a contract of sublease. The main contract is obviously for the use and enjoyment of the property leased by Nardo for a fee. The incidental stipulation is for Paquito to pay the rental fee directly to the lessor Jericho. If accepted, Jericho can demand the rentals due from Paquito. On October 10, 2010, Joaquin executed a deed of absolute sale in favor of Juancho involving the parcel of land of Joaquin situated in Surigao del Sur. Juancho did not register the deed of absolute sale with the Register of Deeds of Surigao del Sur. On October 30, 2010, Joaquin also executed another deed of absolute sale over the same property in favor of Martina, who had no knowledge of the prior sale between Joaquin and Juancho. Neither Juancho nor Martina took possession of the parcel of land subject of the two sales. However, after learning of the October 10, 2010 sale, Martina immediately caused the registration for October 30, 2010 deed of absolute sale with the Register of Deeds of Surigao del Sur. Will Martina be able to invoke the principle first in time, stronger in right as against Juancho? Discuss. Now, this question is about double sales. Sino nga ba ang may priority in case the same property is sold to two or more persons? So here is my suggested answer. No, Martina will not be able to invoke the principle of first in time, stronger in right against Juancho. According to the Civil Code, in case an immovable is sold to two or more persons, the buyer who is first to register the sale in good faith shall have a better right. In case there is no registration, it is the buyer who is first in possession in good faith. In case there is neither registration nor possession, then it is the buyer who has the oldest title, also in good faith. In this case, the property was sold first to Juancho, then to Martina. Martina became aware of the prior sale to Juancho. It is with this knowledge that Martina registered her sale. Such registration is in bad faith. It is ineffectual. It does not vest Martina a superior right. Since there is no valid registration and there is no possession, the buyer with the oldest title in good faith shall be preferred. Here, Juancho's sale is obviously the oldest. Hence, Juancho has a better right. Ibrahim borrowed money from Fidel as evidenced by a loan agreement. Ibrahim used as collateral for the loan his parcel of land situated in Maria Luisa Estate Park in Cebu City. Under the terms of their agreement, Fidel has the exclusive and irrevocable option to buy the collateral for the amount of 100 million pesos, inclusive of the borrowed amount of 50 million pesos and interest therein at 6% per annum. When the loan matured, Ibrahim was unable to pay his loan obligation. Ibrahim, however, refused to sell his collateral to Fidel. May Fidel compel Ibrahim to sell his collateral by exercising the option to buy under the loan agreement? Discuss your answer. I don't know about you, but this one is tricky. We have a rule against Pactum commissorium, but is an option to buy the property granted to the creditor outside or beyond this prohibition? So here is my suggested answer. No, Fidel cannot compel Ibrahim to sell his collateral by exercising his option to buy. The law prohibits a Pactum commissorium, which is a stipulation in a contract that allows the creditor to appropriate the property given as security for the payment of a debt. In this case, Ibrahim borrowed from Fidel and offered his parcel of land as collateral. The exclusive and irrevocable option given to Fidel under the loan contract to buy the land for a price that includes the borrowed amount is a form of Pactum commissorium. Here, the property will be applied to the payment of the loan, that the total price is greater than the borrowed amount, which therefore entitles Ibrahim a supposed return, is immaterial. Hence, Ibrahim is correct in refusing to sell his collateral to Fidel. Luna owns a passenger bus driven by her employee Tomas. One day, the passenger bus collided with a car driven by Graciano. Graciano then filed a complaint for damages based on quasi-delict against Luna. He likewise instituted a criminal action against Tomas but failed to reserve his right to institute a separate civil action for damages in the said criminal case. Luna filed a motion with a trial court for the deferment of trial, arguing that Tomas must be impleaded in the civil case because he committed the negligent act that caused damage to Graciano. Is Luna correct? Explain. Ayan, may tanong tayo on vicarious liability. Kailangan ba i-implead ang employee sa case laban sa employer? Well, here is my suggested answer. No, Luna is not correct. Under the Civil Code, in case of a negligent act committed by an employee resulting in injury to another, the employer shall be vicariously liable. His liability is based on his negligence in the selection and supervision of the said employee. This liability is direct and solidary, and the action for recovery needs only to prove the negligent act of the employee. In this case, Graciano was correct in filing the action for damages based on a quasi-delict only against Luna without impleading her employee. Luna is being held liable for her negligence in the selection and supervision of Tomas, who committed the negligent act which resulted in the injury suffered by Graciano. Of course, even though Tomas is not impleaded, it is still imperative that Graciano proved the negligence of Tomas. Hence, the case against Luna can prosper. Rene and Sebastian, who are bitter enemies, engaged in a gunfight. In the ensuing battle, Rene killed Sebastian with a shot to the head. In the criminal case for murder filed against Rene, the heirs of Sebastian failed to establish funeral expenses due to the inadequacy of the evidence. Still, the trial court awarded temperate damages to the heirs, declaring that it cannot close its eyes to the fact that the heirs of Sebastian indeed incurred funeral expenses. Is the award proper? Discuss. Finally, a question on a specific type of damages. In this case, temperate damages. So here is my suggested answer to question number 20. Yes, the award of temperate damages is proper. According to the law and jurisprudence, temperate damages may be awarded for expenses which cannot be established with certainty or if the evidence is insufficient, provided that the fact of injury and pecuniary loss have been established. In this case, it was established that Sebastian died from a gunshot wound to the head inflicted by Rene. Although the amount of funeral expenses was not definitely established, it cannot be denied that Sebastian's heirs incurred funeral expenses. A reasonable estimate may be made. Hence, the court was correct in awarding temperate damages for the funeral expenses. Yan po mga House of Law and mga bar examinees ng 2023 bar exam, ang suggested answers to the 2023 Civil Law bar exam. To be honest, I find the questions very reasonable, very comprehensive pa. No bizarre, unusual, or treacherous questions. But it was an exam nonetheless. Kailangan talagang mag-aral. Kung hindi nakapag-aral, well, mahihirapan talaga. So how did you fare in the exam? You can comment down below if you wish. Or maybe, just message me or tell me if you see me after you take that lawyer's oath very, very soon. So that wraps up the BAR 2023 season. Thank you very much sa inyong lahat for all your support to this channel and of course to me na rin. It will always be my honor and privilege to be a part of your journey as lawyers. So, I'll see you again in my next video. Laging tatandaan, isip ay buksan, alamin ang batas. Ito ang The House of Law.